Hello, everyone. Welcome back to the Modjeska Simkins School of Human Rights. And today we are honored and fortunate to be able to interview Armand Derfner, one of the co-authors of the book Justice Deferred, Race and the Supreme Court. Mr. Derfner has also been a long-time practicing civil rights attorney who's been involved with a wide range of cases involving voting rights and civil rights throughout the South and across the country. And of course, in the Modjeska Simkins School of Human Rights, we all understand the importance of civil rights, voting rights, and human rights to our everyday lives. So, Mr. Derfner, welcome back to our class.
Good to see you, Dr. Greene.
And again, we're so fortunate to have you. And we're going to jump right into our conversation today because, of course, there's a lot going on with the Supreme Court, with race, with issues of voting and civil rights in America. But I actually want to start things first by talking about the book you co-wrote with Vernon Burton, another friend of the school, Justice Deferred, Race and the Supreme Court. If you don't mind, could you tell us a bit about what was it that pushed you and Dr. Burton to write the book Justice Deferred?
Well, Vernon Burton and I have known each other for now about 45 years. We got to know each other in 1980, right after the Supreme Court had taken a giant step backward by in something called a Mobile case, when they really made it a lot more difficult for people who were victimized by voting discrimination to prove that. The Supreme Court may set up new hurdles. And we've been talking about the issue since that time as the Supreme Court has gotten worse and worse. So even though we thought the Supreme Court was doing badly around 1980, that is nothing compared to what the court has done since that time and threatens to keep on doing if something doesn't change. And so we started talking about it, and we sort of went back to the beginning and tried to project it onto the present. And one of the things that we focused on was the notion that the Supreme Court has different images at different times. People, at least in my day, which is a little bit before most everybody else's, we thought of the Supreme Court as the protector of democracy, protects the right to vote, ended segregation, guarantees fair trials and free speech. But it turns out, as we looked at it, that really goes to a very short period in the court's history, from about the mid-1930s to the mid-1970s. That's 40 years out of 240 of the Supreme Court. And for the century and a half before that time, and for the half century since that time, the court has been really a drag on democracy, has been an institution that really has endangered our democracy. So we wanted to highlight how the Supreme Court has played different roles at different times.
Definitely. I think that's a really important point that a lot of our students are coming to understand more in the Modjeska Simkins School. And to kind of drill a bit deeper into this topic, I would like to talk specifically about the Reconstruction era amendments and their relationship to the Constitution and the Supreme Court. Of course, those are the 13th, 14th, and 15th Amendments. And many historians argue that these Reconstruction era amendments really helped to shape the Constitution as we know it in the 21st century. So could you talk a little bit about how those Reconstruction amendments are so important to the modern U.S. Constitution and debates about the U.S. Constitution taking place right now?
Okay, they really created a second constitution until the 13th, 14th, and 15th Amendments, which we sometimes call the Civil War Amendments or the Reconstruction Amendments, because they were all passed between 1865 and 1870. Before that time, for 3/4 of a century before that, the Constitution was basically a limitation on the federal government. Federal government didn't barely counted for anything. The states were sovereign and supreme. Even the Bill of Rights didn't apply to the states. So if you had the First Amendment said Congress couldn't regulate free speech, the states were free to do whatever they want to crash free speech under the federal Constitution. So those the 13th, 14th, and 15th Amendments created a new relationship in which the federal government had real powers and the state governments had real limitations. And that was what the Constitution, what those amendments were supposed to do. Unfortunately, for a lot of reasons, it didn't really work out that way. And so for many years after those amendments were passed, really until about the 1930s, they didn't count for anything still. And the court was a leader in making sure that those amendments didn't matter at all. So it was only toward the middle of the 20th century, starting in the 30s and building up into the 50s and 60s, that the Reconstruction amendments really began to make a difference. And unfortunately, since the 1970s, the court's been going out of its way to put the states back in control, not just in general, but for the bad things that the states do, and to make some real opinionated rulings on the Constitution, on the amendments. I'll just give you one example, which we talk about in the book. The court goes out of its way, this modern court, to say the Second Amendment is virtually limitless, the right to keep and bear arms, overturning 150 years worth of precedent that limited the Second Amendment to militias, to the state militia. The court likewise has taken the religious clause, the freedom of religion in the First Amendment, and used it to end the ban on establishment of religion. So when I was growing up, religion had a real place in the private sphere, but not in the public sphere. This court is removing that. So the point is, this court is reading the religion clause and the Second Amendment for all they're worth. So if they can read some provisions broadly and to have a major effect, you would think they would do that with the 13th, 14th, and 15th Amendments, for which a horrible war was fought to have, and for which the court at an earlier day had said those amendments would not have been passed except for the war, emancipation, and a desire to free an entire race. But this court, has been interpreting those amendments, 13, 14, and 15, to be the minimum they could be. So they're picking and choosing the constitutional clauses that they like and don't like. And unfortunately, they're picking them in a way that magnifies stratification in our society, that magnifies separation, that magnifies the disadvantaged, the disadvantages of people who are disadvantaged, and really turns our society on its head.
And I want to really follow up on that question, because for our students, they know that the 13th Amendment ends slavery, the 14th guarantees national citizenship, and the 15th guarantees the right to vote regardless of race. But as you already mentioned, all three of those amendments have only been really greatly enforced in a specific time period, 1930s to the 1970s. So could you talk a bit about how those amendments were used in that time period first, and then we'll get to what's going on in a contemporary context?
Okay, I'll give you two examples. Number one, by the 1930s, segregation, segregation was really a form of total stratification and totally unequal society. And the 14th Amendment seemed to have no role. The theory was separate but equal, but it was really separate and unequal. Starting in the 30s, the court started chipping away at that. And by the 1950s, the court said no segregation. The segregation was unconstitutional. And in the remainder of the 50s, after Brown versus Board, and in the 60s, up until the very end of the 60s, and even into the beginning of the 70s, the court was trying to make real not simply the end of formal segregation, but was trying to really make real the promise of equality that the 14th Amendment, Equal Protection Clause, meant. Since that time, they've gone in the opposite direction. Another example is the right to vote. Until about the late 1950s, there really was no right to vote, not only on race or but anything else. And in the 60s and the 70s, the Supreme Court, along with Congress and the executive branch, really created a vibrant right to vote, protecting all races and protecting all voters regardless of race. And there too, at least since in more recent years, the court's been dismantling that piece by piece. For example, we all know about how the Supreme Court about 10 years ago just did away with the Voting Rights Act, did away with preclearance, which was the main engine in achieving some racial equality in the southern states. Court just did away with it. And they did away with it by lying about what an earlier opinion said. They did away with it by quoting, they said, our view on this is supported by a case called South Carolina versus Katzenbach. And then they quoted a sentence out of the South Carolina versus Katzenbach case, except they left out 20 words that showed that they were lying. They said South Carolina versus Katzenbach held such and such, but it didn't. It held the opposite. But they left out 20 words that showed it meant the opposite. So this court has been going out of its way to undo the good that the court in the middle of the 20th century had done.
And I would point out too that you mentioned this goes from the 1930s to the 1970s, and then 1980 we get Ronald Reagan, we get the conservative revolution in politics, and a sea change in the Supreme Court. So I can't help but think about the fact that these Reconstruction or Civil War era amendments were made during a time of considerable turmoil in American politics, but also a time of real potential in the 1860s and 1870s in terms of ending slavery and the like. And then they're being utilized through the New Deal, Great Society era of the mid 20th century. How important do you see these Reconstruction era amendments in terms of safeguarding democracy in the future? Because they're being referenced a lot more and more, especially the 14th and 15th Amendments when it comes to, as you mentioned, voting rights and other key issues. How important will it be for not just the Supreme Court, but even everyday activists to cite these amendments and say we have to utilize the full letter of the law to safeguard our rights?
Critical. And one way to see that is to see what happened in an earlier time. One of the tragedies of American life is that the period after those amendments were adopted in the 1860s, the Congress followed up with some civil rights laws designed to protect the right to vote and protect the newly freed slaves and protect their white allies and to encourage a real democracy in the South. And the Supreme Court of that day just wrecked those laws. They held a lot of them unconstitutional. So, for example, the Congress passed laws in 1870 and 71 that authorized the federal government to prosecute individuals who were violating other people's civil rights. Okay, Supreme Court threw those laws out. And yet, so that in the 1950s, when there were riots to maintain segregation, say Little Rock, when crowds were gathered at Little Rock and throwing bricks and bats at the Freedom Riders in Birmingham, if those laws had not been thrown out by the Supreme Court, federal agents could have arrested the rioters. And a handful of arrests at Little Rock or at the Montgomery bus station probably would have ended those riots pretty quick. And instead, federal government couldn't do it. They didn't have the power because the power that Congress gave them had been taken away by the Supreme Court. So the Supreme Court has the power to nullify what Congress and the president try to do on behalf of the people. And that's what they're doing again. So
now, in your personal experience working on voting rights cases and voting rights issues, how important has the 15th Amendment especially been to your work? Because it has, I think, perhaps become the best known of the Reconstruction era amendments. How important has it been also, especially to the Voting Rights Act of 1965? How important have those two, of course, the Constitutional Amendment, 15th Amendment, and the Voting Rights Act, how important have they been to your career in terms of doing voting rights activities, voting rights actions?
crucial. The I, for example, uh, I did I didn't vote for president till I was 34 years old because I missed, I think, 4 elections in a row because of laws, state laws that disqualified me. Uh,
Mm.
what you had to wait till you were 21 to vote. You had to live in most states for a year. You couldn't vote absentee in a lot of places. All those things. Well, a lot of those things were eliminated by the Supreme Court and with Congress cooperating and so forth. Uh, so those things don't exist anymore. But if this Supreme Court had been in charge in earlier days, those restrictions would still exist. They would still exist. This Supreme Court favors restrictions on the right to vote and uh, uh, and doesn't care and will overturn lower courts that try to get rid of those restrictions. I'll give you a little known example. You know, we all know the dramatic examples of the Voting Rights Act, but for example, there's something called the motor voter law,
Hmm.
passed by the federal government about, I guess, in the 1990s. And one of the things the motor voter law does, in addition to encouraging registration, is it regulates states' efforts to purge voters. You know, sometimes voters have to be purged if they move or die, and so states are allowed to purge voters if they do it in a reasonable way. And a case came along to the Supreme Court in which a state, Ohio in that case, had gone way overboard and kicked a ton of people off the rolls who were still registered. And there was a challenge to that, and a lower court said that challenge was correct. Ohio has gone too far and it's not reasonable. It went to the Supreme Court. The Supreme Court said, oh, yeah, Ohio is just fine. And not only that, they said, oh, this word reasonable in the statute, it doesn't mean anything. When Congress said the purging of voters has to be done in a reasonable way, we don't care about that at all. They just threw that word out of the statute. Congress had put it in for a very specific reason. And this Supreme Court said, we'll just throw it out. So they pick and choose what they like and what they don't like.
I think all of this is, of course, leading to a question many of our students have right now, which is how does this all relate to the current legal issues a particular candidate for president is facing right now? Of course, I'm talking about Donald Trump. Now, it appears that the Supreme Court is really trying to stay away from making any rulings that could get Trump in further legal hot water, so to speak. Although I think at this point that the water is kind of boiling for him. But could you talk a bit about the Supreme Court's role in all of that, in trying to keep Trump in these debates about taking Trump off the ballot in certain states versus keeping him on, and how this is playing out in the legal arena?
Well, the Supreme Court claims to be just calling balls as strikes. That's what Chief Justice Roberts said was the Supreme Court's job when he was in the hearing. That's not what they're doing. So I'll give you an example. There was a case from, as you know, from Colorado, which had kicked Trump off the ballot, and it went to the Supreme Court. And the Supreme Court said, and I think this is actually correct, that the states couldn't do that. There's a clause in the 14th Amendment that says If you've been in an uprising or attempted to overthrow the government, you can't hold office. Okay. So Colorado said, well, Trump has been in an attempt to overthrow the government, so we're kicking him off the ballot. The Supreme Court said the states can't do that. And I think that's correct, because it wouldn't make sense for Colorado to say he's off and Massachusetts to say he's on and Florida to say he's off and some others. That wouldn't make any sense. So it's clear that the federal government is the one to enforce that. But the court went on and didn't have to do this, but said only Congress can do it, making the courts giving the courts no role. They didn't have to decide that question at all. And what they really did is they protected Trump in that way. The other thing they're doing is, when the Supreme Court took up this question of immunity, about whether the president is immune from prosecution, I have to say, I sadly predicted what they would do. We don't know yet what the opinion is going to say, but everybody says, well, the Supreme Court is going to reject total immunity. In other words, they're going to say, president can't just pick up a 6-shooter or a rifle and walk down the street, mowing people down left and right and not be prosecuted. They're not going to do that. And of course, they're not going to do it. But I said, unfortunately, I would turn out to be right. They're probably going to deny total immunity, but they're going to do it in a way that makes sure he doesn't get prosecuted for a long, long time. And that's what they are going to do. They're going to say, I'm pretty sure of this, they're going to say, he's not got total immunity, but he has immunity for certain things like the core presidential function. And before you try him, you've got to figure out which is which. And so it'll take years before he gets to trial. So I knew they were going to do something like that, and sure enough, they are. So while pretending that they are neutral, they're anything but neutral. When, you haven't asked about this yet, but obviously abortion is sort of behind everything. And yet on abortion, we know that the justices who got rid of the abortion right to abortion had that in mind all along. And yet, they got on the Supreme Court by lying about it. They wouldn't have passed the Senate Judiciary Committee to get on there if they really had told what they really had in mind. But they ended abortion with an opinion that 11 times relied on an English judge, Justice Hale of the 17th century, who during his time as a judge spent a lot of it trying, convicting, and hanging women as witches. So that's their authority for getting rid of the right to abortion. The interesting thing is that the court, and this brings us back to the right to vote, by the court restricting the right to vote, they're putting state legislatures in charge and putting the voters out of the picture. And yet we know that state legislatures are in many instances restricting the right to an abortion severely, while the people in those very states have very opposite views. So the Supreme Court is limiting the right to vote to make sure that the legislatures can act like real criminals.
Now, I want to end our interview with some more useful information for our students, many of whom are going to become activists in their own right in a variety of projects, all of whom are deeply concerned citizens. So I'll ask it to you in this way. What would you say to people, citizens, activists, so forth, who are deeply concerned about the direction of the Supreme Court and what it's done on abortion, on voting rights during the era of Chief Justice John Roberts, before him, William Rehnquist? What is it that average citizens can do from here on out to respond to what the court is doing?
I wish I had an answer for that, because part of the problem is that this Supreme Court, more than any other, seems to care nothing about public opinion or about other people's views of the Constitution. This court, more than almost any other in history, I think, is not just a reactionary court, which others have been, but is out of step with the people. When the court in 1896 said separate but equal in Plessy versus Ferguson, the problem is probably most people thought that was just fine. But
Right.
nowadays, the people are just up in arms, I believe. And the courts, the examples of the courts seeming crookedness uh, fits in with that. And so the court's rating in public opinion is really at its rock bottom. And one has to think these justices are not going to last forever. And some of them are going to disappear soon. At that point, it'll depend on who gets to nominate and confirm them. But I guess the only thing we can do at this point is to keep the pressure on, keep trying to exercise power in the in our democracy, and in the end, I think we have to hope that the court cannot sustain its bad role against committed democracy, which means, of course, the elections make a difference too. So
Absolutely.
we have
Yeah,
to
so in
hope
other
that
words,
the elections turn out to really reflect the voice of the people. We have to hope that the people are sensible. Let's
well,
keep our fingers
and
crossed.
fingers, toes, and anything else you can get crossed. Let's keep them crossed
Exactly.
this November because you're absolutely right. There is a lot of work for us to do, but I think the good news is that individuals like yourself and Vernon Burton and others are doing the necessary work of getting information to the people through books like Justice Deferred to kind of help us think about all these topics in a both a historical context and a contemporary context too. So I do want to thank you again and Dr. Burton for your work on this book. And I want to thank you for your work on voting and civil rights as well. And for
Thanks, and
joining us
thanks
this
to
afternoon.
you, thanks to you and Brett and others and the Simkins School. I was Modjeska Simkins was a friend of mine. I worked with her.
Mm,
She was a wonderful person, and the people who come to this school and work with this school, like you and the students there, are carrying on a wonderful tradition and a great torch. And we will prevail. We will prevail.
absolutely. We will
Thanks,
prevail.
thanks so much for inviting me.
Thank you for joining us.